Yes.
So, good evening, dear learners. Today we are going to deal about the block MBA 5 and Unit 52 that speaks about the marriages, custody, adoption, and property related issues with diaspora community. So, it is very important to found upon the uh, to understand the reality on these issues. Just a minute, I have some.
हाँ व्यापार इतना मतलब हतो लेकिन इतना नहीं हो तो गले की बता हुई भैया फैले वो सुना को थे वो मतलब आदमी रोजगार हो ना भैया कोई ना हो वो तो जा ऐसे ऐसे फैले वो
Okay. So to know about the marriages, custody, adoption, and property related issues related with diaspora community. When we are talking about this particular unit, we are dealing on the very important human rights respect related and the laws related things in terms of citizenship, in terms of what happens in the kind of marriage which takes place between the person from the in the homeland, right? So I am moving from here and settling in a US and I am getting married there. So what kind of issues and that I will be facing in it, or what are the privileges I have in terms of marriage, in terms of adoption, and whether I have the right on the property to buy over there in their hosting land. So these are the very important to discuss about and important to learn all those things. So this particular unit will tell us we will learn out of this particular courses what are the issues related to Indian diaspora and the migrants marriage and the divorce in the hosting land, right? That we will understand, and the existing diaspora laws related to custody of the childrens and the rules and regulations or the laws related to adoption, and the other thing is the property issues. So these are the things we will learn in this particular unit, right? So when you talk about the introduction part of the particular unit, we will learn on the how the migration of economic and employment opportunities leads to complex legal and social issues for migrants, right? So a person goes to other land for the economic perspective. You see here today, there are a lot of discussion going in US that the students, those who are coming for the study visa, right? They should only do the study. They should not go and work. Okay, so they are bringing because they are stating that in education visa, it's clearly mentioned that they can only study, they cannot involve in economic activity. So they are very much keen on it, and they are not now they are scrutinizing or going and visiting all the malls and restaurants whether the students are working there because they don't have the permit to work, right? They do not have the permit to earn during their study visa, right? So these are the things we need to understand when we go when the diaspora people facing, and so the diaspora social relationship become more complex and complicated when there are personal disruption in their relationship like divorce or fight over the custody of the children. So this is very important. So these migrants leave their families back in their home country and marry someone else in the host country. So what has happened, that kind of situations? In such a situation, the legal redressal measures for the estranged spouse is different in the host and home countries of the diaspora. So that is also taking place. In addition to marriage, we also talk about, we need to understand the divorce and custody rights of the children. So I'm getting divorced, so what is the custody of the children? So I'm going with a family to certain country, right? Certain country, and I'm living there. Then there is a dispute between my wife and I. Then the divorce takes place. So what happens to the custody of the children? So there are other, so we need to think on that perspective. So, how legal rights and measures of adoption are different in host and home country, and which law applies to the member of the diaspora and the subject to this, right? So, it should be noted that there are other issues related to inherited property of diaspora and migrant, which creates intricate situation while addressing these problems. So this unit will focus on some of the these contested and very complicated issues while taking into account of some of the cases and studies. So that is very important to know, very interesting unit for us to learn. So Indian diaspora and marriage trends. So when we talk about this, uh, we learned in the previous unit very clearly that Indian diaspora is the biggest diaspora in the world, and they continue to retain a strong social, economical, and political ties with their homeland. Right. So it is, we need to understand that while we are studying this particular paper, that Indian diaspora is the biggest diaspora in the world, and it is a social relationship which is the strongest of all the bonds, which helps sustain other relationship, including economic and political ties. So I should have a strong social relationship within my family, right? So that is a bridge to develop or to reach other type of relationship, like including economic and political ties. So there is a significant the difference in the numerical strength because of the disparity in the sex ratio, and diaspora and migrants and often look towards their home country for a matrimonial alliances, right? So also, if you remember, during the colonial indentured migration, when we learned, it was the men who migrated first, followed by their spouses and other female relatives. So in Indian scenario, first the man will go and build a relationship in another country. Then he will take his wife and his family or other female from the hosting homeland, right? So normally Indians prefer to marry an Indian women than foreign women, right? So that is a cultural bond is there. So large number of this when you trace back this history, that indentured migrants were either unmarried, or those who were married would not afford to take their wives along with them to the British colonies where they had gone to work. So some of them even married local native women to establish their family subsequently. So in fact, it was only much later in the 20th and 21st century when Indian migrants began going in large number. So they preferred marrying within their homeland and community because of cultural similarities and Indian family values. So that is very important. So there were other issues like immigration and visa citizenship laws that make settling of these disputes difficult when they have the issues related to social, economic, and legal issues. There is a, so India has a Foreign Marriage Act 1969. So that was enacted in the parliament when they said that it has a special provision for people of Indian origin marrying a foreigner and their due recognition by the court of law. So this is in addition to personal laws related to Hindu Marriage Act, Muslim. We have a different marriage act. for example, Christian Marriage and Sikh Marriage Act. So it is provisions are quite a kind a special marriage act which gives the precedence to other faith marriages. So when you talk about the Foreign Marriage Act, it has a special regulations as like a kind of which has a special marriage act privileges. When you talk about the Foreign Marriage Act 1969, it involves one of the parties or non-Indian citizens, right? So when you say that a Foreign Marriage Act, one of the parties should be a foreign citizens, so that this act is applicable irrespective of the fact that the marriage take place in India or outside the country. Such marriages fall under the purview of the valid marriage act. So whether you are the marriage is uh, uh, done in India or outside India, it is recognized under the Foreign Marriage Act. Okay, so such marriages are factual in nature and it needs to fulfill certain criteria laid by the law. There are few cases of kind. A process of globalization has accelerated such kind cross-border marriages. So when you talk about this, uh, the matrimonial relief in this case could be claimed under the Special Marriage Act 1940. Any disputes, if it happens, there is a case on Bombay High Court case of Minoti Anand and Anurag Subhas Anand in 2011 state that matrimonial relief in this could be claimed under the Special Marriage Act 1954 as the marriage between Hindu couple was solemnized in Japan and were registered under the Foreign Marriage Act. Okay, so the settlement takes place under the Special Marriage Act, right? So this is very important. On what basis this marriage is being registered? Okay, so we have a special Foreign Marriage Act 1969 when where the marriage is being registered. We have that in the privilege of registering that marriage. Okay, so there are a lot of cases in relation to this kind of marriages, but these type of marriages are booming like anything because of this globalization is one part and improvement in the technology and the language and the migration that takes place to the higher level, right? And there is a study also says that the boom in the IT sector. Okay, so these are the various reasons why in the marriage, international marriages that is taking place. So, according to the government, the overseas Indian spouse has the right to possess her own independent domicile, irrespective of her husband's citizenship. She can also have her own nationality, can travel at will and possess property rights. So it is not a gender bias alone. Okay, and a woman has the right to possess her own independent domicile. If, for example, a woman marries Indian, it doesn't mean that she should become an Indian, but she has the right to possess her own independent domicile. Right? We have examples in India also. So the Indian woman married to a non-resident Indian, right, enjoys other specific protection like right against sexual, physical, and economic exploitation, and the right to compensation in case they are deserted by their husbands, and the right against dowry uh, uh, and kind of bodily harassment. Right? Oh, sorry, is that okay now? My face is right. So, according to government and overseas Indian spouse has a right to uh, okay. So we have the Foreign Marriage Act, Special Marriage Act, which talks about that, and so that's what I would like to say that where the if a woman marries uh, the the person from outside, non-resident Indian, she has all the privileges like what the Indian law says. So physical and economic exploitation and right to compensation in case of any kind of harassment and everything, right? So that we that is very very important when we talk about this thing. And in case of matrimonial dispute leading to divorce or any kind of dissolution of marriage between two consenting individuals, there is a definite legal framework that is sought during the time of settling the dispute. So what is the Indian laws speaks about the when they move to divorce? So, according to Indian law, the ground of divorce for overseas Indians is when one spouse enter into sexual relationship or adultery with another person, right? Or desert the spouse for more than 2 years, or infliction of mental or physical cruelty. So, there is a kind of leaving the wife or husband, making them destitute, and or the conversation of the spouse into another conversion of the spouse into another religion, or when the spouse disappears or is untraceable for more than 7 years. So in these type of cases, a person can go for divorce. Once again, I repeat it: when there is an adultery or enter into other kind of sexual relationship, or kind of destitute, leaving them without giving them care on, or cruelty of mental or physical cruelty, conversion of the religion, or untraceable more than 7 years, or the spouse disappears, right? So in that cases, a person can go for either husband or wife can go for the divorce. So in case of mutual consent seeking divorce, none of the cited reasons could be the cause of the dissolution of the marriage, while holding mutual consent as the reason, right? So when I have, if I have the mutual consent, my wife also agrees and I also agree, I need not, I need on mutual consent we need not to show anything like mental harassment or something. Mutual consents, both can go and have get the divorce from the court. If it is mutual consents, I need not to bother about whether these kind of uh, cruelty or untraceable and everything, right? So for seeking the divorce, for marriage solemnized in India and the subjects living overseas, there are procedures laid down for it by Indian judiciary. So you have uh, solemnized your marriage in India, right? Your marriage is registered in India and living abroad, right? So in order to seek divorce, the husband and wife should be staying separately for the proceeding 1 year, uh, 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 proceedings 1 year before they give a joint application of divorce. Okay, so for example, uh, okay, I will answer your question. I will give time to answer your question. Don't worry. Uh, Probably your answer may be clear during my class, or else we will at the end of the class we will have a question. Okay, but post your question, not a problem, but I will answer, right? So when I talk about the in order to seek divorce, the husband and wife should be staying separately. That is one thing. The application is based on the premises that both husband and wife cannot stay together as part of the matrimonial tie, and judge issues a notice after 6 months for a joint application. If both partners do not change their mind and insist on divorce, the same is enforced. So as like the divorce that takes place normally here, right? uh, when we talk about the, in addition to divorce, Indian legal system also provides the provision of judicial separation, right? An applicant seeking judicial separation appeals to one of the or all of the reasons on which the divorce is sought, but does not divorce per, but leaves separated from the partner, right? They are uh, uh, there is a separation, not exactly divorce, they are separated. So the person who has sought judicial separation cannot marry a person to be husband and wife, unlike the divorced person who can unmarry, right? If they are separated, means that they cannot go for remarriage, right? They are not divorced, they are separated. There is a provision called judicial separation, right? While divorce puts an end to marriage, judicial separation does not end the marriage but allows the partners to live separately while retaining their matrimonial ties, right? So the partners who have sought judicial separation can live together as husband and wife in future if they so wish without the need of getting married again. So there is a main the difference between the separation, judicial separation, and divorce, right? So when we move to custody, adoption, and property, or conversion, we go with the thought of custody of children. What is the custody of children? So you got divorced, right? A husband and wife got divorced, then who takes care of the children? Who is the custodial or guardian of the children? So that is a main concern. So when the husband and wife divorce each other, the question arises with whom should the children live with? Okay, that's very very important. We talk about in the perspective of the Indian law. Please, we need not to talk about what the law says in US or something, because what happens in the Indian diaspora when they live abroad, okay, when their marriage is solemnized in India, right? So according to Indian law, it is a mother who has the first right to the custody of the child who is below 5 years of age, right? Very very important. So it is damn sure that if it is below 5 years of age, the child will be in the custody of the mother. Okay. So it is based on the premise. What is the premise? Premise, when you talk, say that premise, it's a kind of a taken statement, or some kind of truthness in it. Okay. So it's a premise that young children need maternal support for sustenance and after they leave, after they have grown. Right. So they need a motherly care. So an earning father would look after their material needs. So the laws relating to custody of children depends on the religion of the parents. Why we have separate marriage act in India, right? So the Hindus, Muslims consider father as a natural guardian of the children, where Christian and Parsis do not have any such distinction whether when natural guardianship of the children is concerned. In such cases, Hindus' custody laws are governed by Hindu Minority and Guardianship Act and Guardians and Wards Act 1890. So the custodial cases in Muslims governed by personal law along with the Guardians and Wards Act 1890. So each uh, uh, law related to based on the religion has a different opinion on it, so that the government is planning to bring the uniform civil code to have a particular system without looking into any religious values, like uh, when it comes to marriage, adoption, divorce, and all those things, right? So in most of the cases, interest of the children, their consent are sought in resolving custodial disputes. That is one thing we need to remember. So it is the interest of the children after 5 years, right? So under the Hindu law, father is considered a natural guardian, and the ultimate right of custody rests with him for children above 5 years and below 18 years. So the Supreme Court of India, in one of the cases with the Gita Krishnan, Harikaran, and the Reserve Bank of India, held that the right of the custody of the child would rest with the mother only in the death and absence of the father of the child. Okay, the Supreme Court of India has given its verdict. All right. So the child would rest with the mother only in the death and absence of the father. So in case of unwillingness and inability of the parents to hold custody of the child, the court can grant the custody rights to the close relatives. Okay, there is a possibility. So there are clear law as to whom the custody of the child cannot be given. So to whomever it should not be given. So for example, it cannot be given to either of the parents who have certain habits which could detrimental to the upbringings of the child. For example, they are not mentally fit. Okay, they are all highly drug abuse, both father and mother. Okay, or they are not able to understand the or they give lot of torture to the child, right? Cruelty, or they abused the child. So in that cases, uh, the court may say that the child should not be given to the parents, right? Which determine or upbringing of the child will be very very difficult. And who has converted to other religion or has renounced the world. Once the custody rights given to either of the person, the other person have the visitation right to visit the child as directed by the court. Right? I hope in most of the movies we might have seen it. Right? If the child is given to the father, the mother has the right to visit. Right? So the court will give that time and which day or which in a month how many times, or in a week how many times, how many hours the another parent partner can go and visit the child. And yet another landmark judgment in another cases allowed that relocation of the mother and the child to Australia, thereby changing the visitation right of the father. Right. So in most cases, the interest and welfare of the child becomes the guiding principle. So what is the child's requirement? Okay. So based on that, this the custody of the child will be determined by the court. So as mentioned, when we talk about the Hindu custody law, father is considered the natural guardian of the child, right? So when you talk about the uh, 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 father's custodial rights, this has been contested that the law is discriminatory in nature and deprives the mother of maternal rights at one stroke. So here we talk about that it was keeping in the mind that the section 19B of the Guardians and Wards Act amended by bringing parity between the custody right of the mother and the father, right? And it clearly says that mother has also been he given should be given equal right to take the custody of the child, because the amendment took place in the section 19. And in case of Muslims under the Shia law, the natural custody rests with the mother till the male child achieved the age of 2 and the girl child achieved the age of 7. So the mother's right to custody continues even when she is divorced, but cases to exist only if she is remarried. Okay, what happens if it is remarried? So the custody will not be given to the mother. So in such cases, interest of the child and the consent is taken, deciding the custodial rights, right? To whom the child wants to stay. That is very very important area. While the above mentioned cases relates to Indian custodial rights of Indian citizens, but it's applicable to overseas Indians as well. So please remember, this is applicable to overseas Indians. But what happens when the child is born outside India, right? So in that case, she or maybe the citizens of the country where she is born according to the citizenship law. What happens when both or the either of the parents migrates to other countries? In such a situation, will the home country of the child change, or she migrates with the other of the parents? So there are some of the complex family issues which arise because of migration and dislocation. When you look into this, as there are multiple countries involved, so the child is uh, see in case the citizen of the country where he is born according to the citizenship law, what happens when the either of the parents migrate to other countries? So it has a multiple. He is born in India, and the child was born in Australia. From Australia to they migrated to some other countries. So when you look into these cases, it has a lot of multiple countries involvement in it. Okay, so here, thus this type of disputes are resolved taking the source of Hague Convention. Okay, Hague Convention 1980, which lays down rules in resolving such cases. There are some 96 member countries which have ratified the common convention and have agreed to follow its resolving family disputes. So they have a Hague Convention in HAGUE that clearly tells about what should be done when they have a multiple countries involved, right? So I got married. My marriage is registered by Indian in a Hindu marriage act. So I live in Australia. So I give the birth to my child in Australia. Then I moved to US. So what is this type of in these conditions? So the Hague Convention 1980 gives, and 96 countries have uh, signed in the convention. What is convention? It is a simple, but you sign it. For example, child labor. UNICEF or has given a lot of things to reduce the child labor. So India has signed in the most of the conventions. Mean that the laws are taken to reduce the child labor in such areas where the India has signed. So in the same way, kind of this convention takes place. So one of the major issues while deciding such cases is a jurisdiction area of the complaints, right? What is the jurisdiction area? Okay, this cases to be taken. It means which country or court is authorized to decide such cases. Any court which hears such cases should have a child custody. Okay, or judge the issues. Understand? Very, very important. In out of this, so three countries are involved, should look into which country is authorized to decide such cases. If the countries have taken this case, it should hear right to hear, and it should have a child custodial jurisdiction. That rights they should have. In deciding such cases, most countries have followed Uniform Civil Jurisdiction and Enforcement Act, okay, which is given by Hague Convention. They should have a uniform child jurisdiction and enforcement act. Means that the child is defined, what is custodial is defined, whom to be given is defined, everything is defined uh, to whomever the country is involved in these cases. So these rights, however, change when the parents and child move to another country. So in such cases, the laws and regulation of the home country are so no longer applicable, right? So no longer applicable because it goes to the international court, such as, right? So no home country, no the kind of the for example, if the marriage had happened in India, no. So that rules, those act will not applicable here. So they will go with the Uniform Child Jurisdiction and Enforcement Act. Okay, if the either of the parent take the child forcefully without the legal rights, such case falls under the purview of child abduction and child removal, which are addressed according to civil aspects of the international child abduction. Okay, so they should not take in such cases. So, but what happens in the area in kind of in case of India? So far India is not a signatory to the convention. It is not mandatory for her to follow its regulation. In such cases, uh, there are kind of other rules and regulations. Uh, who the particular parent who was wrongfully taken the custodial right of the child put in force to resolve the case under the article writ of habeas corpus. Okay, we might have habeas corpus cases. Okay, so if the parent is taken her own child wrongfully under the either of the parent wrongfully taken the custody, then habeas corpus cases can be filed. Means that either of the parent can file a case or anyone can file a case. This child is missing. Please find it. Though the child, then it's a duty of the police to find the child and tell where is the child is. Then the court will decide whether the abduction, the custody is right, or it is falls under abduction or trafficking or whatsoever, right? So Indian judiciary has made some remarkable judgment in relation to custodial rights of the children, right? So it gives the very clear cut idea about to whom the child should be given. So custody is a very important aspect. Please read your even your material on the various issues related to with the custodial of the children when it taken to in various cases. Okay, so let us move upon the adoption. Okay, when you talk about uh, uh, the adoption related things, right? Uh, that also very important whether I can go for adoption when I am in abroad. Okay, so when you talk about the uh, international adoption, it also refers to the, or another term they call it as a stranger adoption. It refers to relocation of adopted children from one country to another, depending on the parental and guardian immigration, right? So, uh, just like the legal issues of marriage, divorce, and custodial rights of children, Indian legal system has laid out rules and regulations related to for adoption of children by overseas Indians. So, what as an overseas Indian, whether I have the right to adopt a child, right? So, when you talk about the adoptions, very important issues related to it, right? So in India, if you see, I cannot adopt a female child. A male cannot adopt a female child if the child is just 5 years younger than me. So at least the age difference is more than 15 to 18 years if I want to adopt a child, right? So there are a lot of things. Even it is not that easy for Indian itself to adopt a child in India. So the same way, in fact, of when talk about adoption of Indian children, is one of the contested issues, as there have been cases of misuse of law leading to neglect and abuse, exploitation, and maltreatment of the adopted Indian children. So there is a we have a CARA, means Central Adoption Resource Authority of India, and Women and Child Development Ministry looks into adoption cases and in safeguarding interest of the children. So the children adopted by non-resident Indian or overseas citizens of Indian or foreign parents are monitored and regulated as per the guidelines of the adoption. That is very guidelines of the Adoption Regulations Act 2021, right? So it is highly monitored by the CARA, that is Central Adoption Resource Authority, which looks into that, and Women and Child Development Ministry, because the exploitation and trafficking is high in the name of adoption. Okay, right. So as per the law, the parents, if the parents move to another country within 2 years of adoption, the Overseas Mission of India are asked to investigate such cases and send periodic reports to the home country, and also contact the authorities of the adopted countries in case of ill treatment to the children. Very important. So you are in overseas Indian in Singapore. Okay, you adopted a child. Within 2 years, you are moving to another country. You should report that incident to uh, the home country, right? If any cases related to it, immediately should be addressed to the home country. So in India, children are adopted as per the Hindu Adoption and Maintenance Act 1956. right? To make it easier, the government of India has now allowed NRIs, okay, non-resident Indians or overseas Indians, OCA, issued a card, okay, or they should have a card holders, NIRA card holders, to take the adopted child to their country of residence after receiving the no objection certificate from the concerned Indian authorities. That is very, very important. As we have said, the action in the law has facilitated through the action was initiated by the Hindu Adoption Maintenance Act, had no provision of inter-country adoption. So the change in the law has facilitated NRI couples, as they had to previously go to the court to obtain the order for taking the adopted child out of the country, right? So we need to understand that the Hindu Adoption and Maintenance Act has no provisions to adopt a child and take the child to the foreign country. Okay, it has no provisions of inter-country adoption, right? Inter-country adoption, so that the law has now facilitating how the NRI couple, they should move through the court, had previously moved to the court in order to taking the adopted child to out the country. But the new law, while facilitating adoption, has also ensured security of the children who were yearly trafficked into the carp of adoption, right? So that they put lot of restriction when the NRI adopts a child. The Kara, that is Karen, which falls under the Ministry of Women and Child Welfare. Overseas Indian citizens are treated as per with the resident Indians in matters of adoption, right? Or surrender of the children. Okay, surrender of the children is different from the adoption. Surrender of the children, you surrender your child, right? You cannot take care or something like that. Okay, or abandonment of the children. All right. So when you adopt or surrender your children, you are considered as an Indian. Okay, you are coming into the purview of what the Indian law says. So they are also required to follow the eligibility criteria for adoptive parents before applying for the adoption, right? So as per Hague Adoption Convention, the child is entitled to receive the care and protection of the country. Okay, what the country's rules and regulations says, as per that, they should get all the care and protection, right? The child can also be adopted by Indian citizens living abroad after following due course of law and applying for the same through Indian diplomatic mission. So they should follow the rules and regulations, and they should register before getting the going through the process of adoption. Okay, so the international adoption came to be widely used in the means of adoption as per the rules of Hague Convention. There is, however, some ambiguity related to the grant of citizenship nationality to the adopted children, right? So in the Indian citizens law, there is no provision for granting citizenship to internationally adopted children by Indian parents, those who are raised in India. Okay, so Indian citizenship law, there is no provision for granting citizenship, right? So as per section 22 of the adoption regulation, all they need is a foreign passport and Indian visa. So the minor child of an Indian citizen under section 5(1) has to be registered with the central government under rule 6 of the Citizenship Act 2009. Okay, so Indian law clearly says the citizenship is blocked for the adopted child, right? So here uh, the rule of citizenship 2009 has to declare the legal guardianship of the minor child. In such case, Indian citizenship can be acquired through the process of naturalization by a foreigner who is not an illegal migrant and has been resident of Indian for minimum 12 years. Okay, so in both, if they are resident of 12 years, they can go for getting a citizenship, right? The same, and they should not be illegal migrant. So the same procedure could be applied to adopted children who is not an Indian citizen. Okay, immediately they cannot get a citizenship. They should reside for 12 years. In contrast to India, the US grants automatic citizenship to all children adopted by the American citizens. Okay, but US it is different. So I am going there. So I am a US citizen. I am adopting a child from India. That child immediately gets the citizenship of US since I am living there. So that now a lot of issues are arising there, and Trump is even doing the President Trump is even taking these kind of issues and doing lot of the Citizenship Act, bringing lot of amendment in which a lot of the provinces are the judgment are against uh, president's US president's view, but there is an issues also going on in that perspective of citizenship act, right? uh, Whereas in India, the child or the foreigner who is residing in India, if the parents are residing more than 12 years, they get the citizenship. The child, even though being adopted, it has the protection, but not getting the citizenship. Then the child also should be there for 12 years. Okay. When you move to the property rights, so citizens who migrate to other countries or for higher studies, employment, and business continue to retain their movable and immovable property right like any other Indian citizens, right? So Indian citizens who migrate to other countries for higher studies, employment, and retain their immovable and movable property rights, what they have in India on their name. Okay, so this basic understanding. So in fact, in the introduction of overseas citizens of India, further they have the right to overseas Indians who cannot only inherit the property of their ancestral but also buy new properties. Okay, so overseas Indians, they have the right to get their ancestral property, and they have the also right to have buy the land or property in India. It is for these reasons the Indian relators have developed NRI cities. So NRI wish towns in places like Delhi, Bangalore, Kolkata, Chennai, and other cities. Okay, so they want to buy, right? According to Foreign Exchange Management Rules 2019, NRI and OCI card holders do not need the approval of any government authority, including Reserve Bank of India, for buying and selling properties other than agricultural land, plantation property, and farmhouses. They can buy and sell. So, however, as per the government rules, they can inherit and continue to hold agriculture land and farmhouses, which is the inherited property. Okay. So I am overseas Indian. I can take it from my parents or ancestors, and I can hold those property, but I cannot buy. There is a regulation. I can buy, but there is a regulation. But other properties like any kind of land apart from farmers or agricultural land, I having the free hand to buy and sell it. So they can acquire and transfer their both movable and immovable property like any other citizens, right? So this it is relating to the property rights. So the overseas Indians have given the same investment opportunity in any other assets like Indian citizens, and but they different in terms of sale proceeds from the India, right? The amount they pay for as a taxation or something, it is different. So, so while Indian citizens invest and retains the proceed from sale, the overseas Indians has the right to repatriate the amount to the place of their residence, right? So they have some rules and regulations which they need to uh, uh, it is a kind of thing which they look into for. So it is not that easy of a normal Indian citizens to buy and sell it, but they have uh, need a kind of verification system is severe, and go through these police verification and all those things. There, for example, there are about 11 NRA police station in the state of in the state for in India for addressing the overseas Indians complaints property disputes. A large number of these cases filed by Indian settled in Canada, US, and UK and Australia. Right. So there are 11 NRA police stations across India to look into these cases. So, looking the large number of NRI dispute cases, Punjab has been planning to enact NRI Property Safeguards Act to look after their interest in providing speedy and transparent resolution of the property related disputes. Right. So they live a long time somewhere and their property they will register and sell it. Right. So those who know the property, they will make a false documents and do it. So that kind of things is happening. So uh, each state is bringing like Punjab has brought the NRA Property Safeguards Act. So we also discuss about the important aspect when you talk about the uh, kind of uh, uh, adoption challenges and safeguards of adoption we have talked about. We need to bit discuss on the Hague Convention, right? When you talk about the Hague Convention, it gives the uh, overall with cases multiple with various countries which need to be discussed in a international forum. So for that, this convention has come in, and India is not a signatory of Hague Convention uh, uh, because it thinks that laws would put unnecessary pressure on Indian women who are trying to escape harassment, bad marriage, and domestic violence. So India has not signed in it. So look into these cases of inter-country removal and the retention of children. The government of India set up Justice Rajesh Bandal committee who to suggest ways in resolving the intricate legal dispute. Uh, so that they brought draft legislation called International Child Abduction Bill, and the Bindal Committee has suggested for the inter-country parental and child removal disputes and all those things. And Ministry of Women and Child Development, Ministry of External Affairs, Law and Ministry. You know that in the Ministry of Women and Child Development, there is a separate portal for overseas Indians or the domestic violence. If it is there, they can register. For example, if you are going there, Dubai as a family, and there is a domestic violence, you can register a case in the using that portal. So there is a lot of things. Uh, Things when we look into that type of uh, things when it is an international things taking place, right? So these are all about the uh, cases related to uh, kind of marriage, adoption, uh, custodial, and all those things. Any doubt in it? Very very interesting and kind of involves a lot of law. Okay, so deep reading will help us in understanding these issues, right? So what happens it's when you imagine itself it is very difficult. When you imagine what happens if they go and commit in matrimonial relationship and then divorce and where, all right. So basic understanding that if that is if they don't, if just a diaspora community having a kind of uh, divorce and everything, then they should uh, the main concern is the home country, right? So that's very very important understanding we should have in so we will move to the unit 53, that is human trafficking. I will give it just a pause here. So